Good morning. This is Judge Elisa Bettis presiding over the 210th District Court Civil Docket for October 16th, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Let me go ahead and go to your case, Mr. Biganowski. This is cause number 2023 DCV 2343 Jesse R. Sanchez individually versus Doe 1. May I have announcements, please?
Yeah, for plaintiffs, Your Honor, Victor Biganowski.
Randy Grambling on behalf of the defendant, Your Honor.
Soraya Yanar Hanshu, court-appointed guardian ad litem.
Thank you, counsel. I show that we are scheduled for the friendly suit, but this has been reset 1, 2, 3, 4, 5 times. And so I have this also set for a status conference. How about we have an update? I'm assuming the friendly suit is not going, but I could be wrong.
Your Honor, we've worked very diligently and we are actually ready to proceed today.
Oh, okay. Let me double check, Ms. Hanshu. I don't, did I receive your report?
You did a long time ago, Your Honor, before we thought we were moving forward, but let me recirculate that. There have just been some updates in regards to the lien.
Okay. The lien was partly, I guess, what was holding things up. So
that is correct. There was issues with the lien. There were also issues that there were potentially outstanding insurance policies that had not been pursued. At this point, Mr. Biganowski has pursued all of those potential recovery policies and has found that there is no additional recovery, which is why we can move forward today. I have not updated the ad litem report for the lien, but I'll circulate what was originally filed. And then I'm going to attach the lien that Mr. Biganowski just sent to us. Is there a specific email, Your Honor, or should I send this to the court coordinator?
Yes, to Ms. Hernandez, please, if you'll send it to her. I was just doing a quick search in my emails because I thought I had seen one before. It's not coming up in like the last 20 emails that I have on this case. So it'll just be easier if we do it that way. And if it's updated, even better. I would prefer to have the updated report, please. Okay. All right.
Yeah, sure.
In that case, then let's go forward. All right, Mr. Biganowski, we're set for a friendly suit. You may proceed.
Yes, Your Honor. Okay, Your Honor. This is a case filed by Layla Sanchez's father, Jesse Sanchez, on behalf of her daughter. Back January 9th of last year, she was a passenger in a vehicle being driven by her sister. They both were involved in a horrific accident. They both, as a result of the accident, went to UMC hospital, where they stayed anywhere from 4 to 6 weeks. The recovery has been long for both of them. However, there are success stories. The driver of the vehicle, Ideli Ortiz, recovered to the point where she went back to college. She goes to New Mexico State University, and she's doing well there. Layla, the object of this suit, took a little while longer to recover. She's been in therapy. She's been to Colorado for some therapy. Her father is here today. And if it please the court, I'd like to begin with the questioning of Ms. Sanchez's father, Your Honor.
Yes, sir. I do need to swear you in. If you would please raise your right hand. And I'm sorry, your name, sir?
Jesse Sanchez.
Mr. Sanchez, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I do.
Thank you very much. You can put your hand down, Mr. Biganowski. You may proceed.
Yes, ma'am. Mr. Sanchez, you're the natural father of Layla Sanchez, correct?
Yes, sir.
All right. And at the time of this accident, your daughter Ideli Ortiz was driving the vehicle and Layla Sanchez was a passenger, correct?
Yes, sir.
And is it correct what I just told the court that your daughter went to UMC hospital and was there 5 to 6 weeks, and it has gone through an extensive period of physical therapy? Is that correct?
Yes, sir.
Okay, and as a result of the therapy, please tell the court how your daughter's doing today.
She has been able to learn how to walk again, talk again. Her fine motor skills are improving. Her balance is something that's still an ongoing issue that she's currently working on. She's gotten most of her strength back in the right side of her body.
Okay,
She's returned back to school. She's on pace to graduate high school on time.
and she just had her 9 weeks tests, and how did she do?
She passed all her 9 weeks report card grades, and she's on track to graduate on time. And her plans are to go to UTEP for 2 years and then transfer to the University of Colorado.
And take what major?
She wants to be a physical therapist.
So you understand in this lawsuit, we filed the lawsuit. Actually, it was your insurance policy that we filed using that, and we filed against Delhi, and you had a $30,000, $60,000 policy. Is that correct?
Yes, sir.
And is it your understanding that the insurance company representing you has tendered their policy limits of $30,000? Is that correct?
Yes, sir.
Now, there's been some issue as to whether there was any other medical or insurance coverage proceeds that might be used in this case. Is that correct?
Yes, sir.
All right. Now, we've made extensive efforts, and I've used you also to try and find out if there was any additional policy. And one of those policies that we checked into was the natural father of Idali Ortiz. And we got a copy of his insurance policy from Elephant Insurance, and it showed that Idali was not covered on that policy. Is that correct?
Yes, sir.
And I provided that deck sheet to all Mr. Grambling and Miss Henshaw, Your Honor. And then Miss Henshaw brought up the fact, well, maybe the natural mother, who was Crystal Orozco, who lives in New Mexico, up in Albuquerque, she might have a policy that might afford your daughter some coverage. Is that correct?
Yes, sir.
All right. Now, you're the managing conservator for Layla Sanchez, correct?
Yes, sir.
All right. And your daughter has never lived permanently with with her natural mother in Albuquerque, correct?
Correct.
All right. Now, we've made inquiries, and you have also, of Miss Orozco to see if she had any insurance. Is that correct?
Yes, sir.
And tell the judge your experience with Miss Orozco.
My communication with Miss Orozco isn't very good.
You need to keep your voice up, sir.
Yeah.
My communication with Miss Orozco isn't very good. She prefers not to talk very much with me. So when I reached out to her to try to get the documents from her insurance, she refused and didn't answer any more calls from me. Layla also reached out to her to see if she can get some copies of those documents, and she didn't get a response either.
To follow up on that, Your Honor, the information I received, I wrote a letter to USAA Insurance Company to find out if there is a potential policy that would cover Layla Sanchez. And I've asked Layla, she doesn't have a driver's license at the present time, correct?
Correct.
And she doesn't have a driver's license in Texas or New Mexico, is that correct?
Correct.
All right. And I sent a letter which has been provided to Mr. Grambling and Miss Henshaw. And I called USAA myself to confirm whether there was any policy for Crystal Orozco with USAA Insurance, which is what she told me she had. And they confirmed there was no such person named in their computer base. So there was no insurance policy with USAA covering her. Since the daughter's never lived with Miss Orozco, she's always lived in El Paso and gone to school here. She doesn't have a driver's license in New Mexico and Texas. It's my opinion, based on my efforts, that there is no additional insurance. So Miss Henshaw and I said that maybe it'd be good just to have this conversation about any other insurance with the court and answer any of the court's questions regarding any additional insurance, Your Honor.
All right, thank you, Mr. Biganowski. Is there anything else from Mr. Sanchez?
I do. You understand in this lawsuit that this is all the money that your daughter will get.
Yes, sir.
Do you understand that by settling today, you're giving up the right to trial by jury, correct?
Yes, sir.
And you know a jury could give you more money, less money, or the same money, correct?
Yes, sir.
All right. And you understand based on your conversations with Ms. Henshaw and myself that this is it. Your daughter will not be able to bring any other lawsuit against Miss Ortiz in the future, correct?
Yes, sir.
All right. You know how she's doing in school. You just said she passed her test and her aspiration is to go to college. Is that correct?
Yes, sir.
Right. And understanding all of that. This is all the money that your daughter will get based on this lawsuit today. Do you understand that?
Yes, sir.
And once this is over, there won't be any more money.
Yes, sir.
And looking at all the circumstances of your daughter, understanding what we just talked about, do you recommend to the court that this settlement be approved?
Yes, sir.
Now, in this settlement, the Optum lien originally was $660,000 from UMC. You understand that?
Yes, sir.
And then we got it down to $277,000. You understand that?
Yes, sir.
And finally, took so long, Your Honor, the lien was knocked down to $10,000. You understand that?
Yes, sir.
And I've provided proof of that to both Mr. Gramling and Miss Henshaw that hospital lien that was originally $660,000 is $10,000 and it will be paid out of this settlement. You understand that?
Yes, sir.
And the attorney's fees and expenses are $5,000. You understand that?
Yes, sir.
And the rest of the money from Progressive Insurance Company, which is a total of $30,000, $15,000 will go into the registry of the court on behalf of your daughter. You understand that?
Yes, sir.
Okay. And understanding all that, you still recommend this settlement to the court.
Yes, sir.
Okay, Your Honor. With that, I pass the witness, Your Honor.
All right, Mr. Grambling, do you have any questions?
Not for this witness, Your Honor.
Thank you, Mr. Grambling. Ms. Henshaw? I'm sorry, you're muted?
Sorry, Your Honor. I just wanted to clarify the lien since that was information we recently received with both the client and Mr. Breganowski. So Mr. Breganowski, what we have is the $10,000 reduction. In terms of the final lien, is there documentation that reflects that the lien has been satisfied or closed? I think that's something that ultimately we just need for the file.
Well, it's in the email from Optum, which represents UMC in this case. And they said, based on my representation, that it's a $30,000 policy. They'll take that $10,000 to satisfy their lien. If, of course, there's any other money that comes available, then I'll have to get with them regarding any other money they may be entitled to. But that's it. It was the email from them saying, that's it. They'll take $10,000 to satisfy their lien.
Okay, what I have unfortunately is like a portfolio.
I sent you the email from them. Did you read that?
I
From-
do, I have that. I was hoping that the final lien PDF is something that we could attach.
Well, the final lien PDF was the original lien. The
Right,
email,
and that's what
it
I'm
shows
looking at.
Optum's the lien holder. The email says in satisfaction of their lien, they'll take $10,000 as long as this case settles for 30. I don't know what else you would want. I don't.
What we
I mean-
need to do is get, we're gonna need to, if the hospital lien is still reflective in on the county thing, we're gonna need to get something saying that they're not, their bill's been satisfied and they have no active lien.
Yes, that's usually what we receive. We just receive basically an account settled. If the court is going to approve based on what the numbers are now, and you know what, Your Honor, I think I did not send you the current one that includes those numbers, so I'll resend that email to Ms. Hernandez. We would just need something that shows satisfaction, because you're correct, when I hit the PDF, What I have is the full lien, but I don't show that there's a zero balance. But I believe that this can proceed based on what you've presented thus far, if the court accepts that.
I'll
It's
follow
for the
up with
court
that,
to-
Your Honor.
So
I'll follow
let me
up
go
with,
ahead, Mr. Boganowski, let me go ahead and interject here. I'm happy to receive any testimony and any additional information we have on the friendly suit. But I can tell you right now that with respect to that lien, I am going to want to see something that is final, dispositive of what the status of that lien is. And I am understanding you to say that Optum, in a sense, it's kind of, I'm seeing two arrows. As long as this settlement is approved, it'll be $10,000. So I don't know if it's a chicken egg situation, but I want something more formal than an email. And so it
and I've
sounds
requested that from them, Your Honor, and
okay.
they said they do.
Okay. Knowing that issue is outstanding, I'm happy to continue with the hearing at this time.
Thank you so much, Your Honor.
Okay.
I believe that Mr. Boganowski has asked the majority of the questions that I as an ad litem would ask. I think I'll just wrap it up and confirm that there was a conference between the minor's family, who's represented by her father, and myself. So if you'll allow me just to ask a few questions, Your Honor.
Of course. Yes.
Good afternoon, sir. Can you hear me?
Yes, ma'am.
Thank you. I would just like you to confirm to the court that we have had prior discussions regarding your daughter Layla and this present matter, being that I was appointed by the court as Layla's guardian ad litem. Would you indicate that's correct?
Yes, ma'am.
Ultimately, what is the current diagnosis for Layla medically?
She has a traumatic brain injury, and that's what she has right now, that she's still recovering from.
Is she going to proceed with further medical treatment?
Yes, ma'am. She does therapy.
Is it your testimony to the court today that you will not require any future funds for that medical treatment?
That's correct.
And you understand that any of the money that Layla receives will not be attributable to any future medical costs. That money is solely for her use upon her turning 18.
Yes, ma'am.
And you understand and will testify to the court that once the court accepts the settlement, that the money will be placed into a trust for Layla, and that is money that she will access through the court registry upon turning 18, providing proof of her identity.
Yes, ma'am.
Is it your wish to accept this money and end this legal case?
Yes, ma'am.
And do you have any apprehension whatsoever to proceed to finalize this matter, or to request that the court finalize this matter on behalf of Layla?
No, ma'am.
Thank you very much, and thank you for your time in trying to get this process done over the last few months. I appreciate it. Thank you, thank you, Your Honor. That's all I have.
Thank you very much. Mr. Boganowski, did you have anything else for Mr. Sanchez or Mr. Gramling? Anybody?
Nothing further, Your Honor.
Thank you, sir. Okay, Mr. Boganowski, anything else?
No, Your Honor.
Okay, so the court is obviously going to await a couple of things. Ms. Henshu's updated report, and frankly, I don't know what a turnaround time would be to get some of this information regarding the lien. Ms. Henshu, if you feel that that is something you want to wait on before you send an updated report, what is y'all's best estimate in terms of when we can expect that?
From my part, a couple weeks, Your Honor.
Okay, then I am going to continue today's hearing for 30 days. Basically, what I'll tell you is this: if you have that any sooner and Ms. Henshu has reviewed it and you would like to submit it to the court via email, I can review it then if you'll give us the heads up, at least that we see. I'll be out next week. So if it's super soon, then it'll take a bit to get it. But
Right,
I
you're
will certainly review it then, and if I feel we need to come back at a hearing, if I have any questions, we'll utilize that date. If not, please make sure that in addition to the report and the lien information, that you send any documents, any proposed documents that to approve settlement, so that I can review those, okay?
Thank you, Your Honor.
Thank you, Your Honor, and we will circulate by email once you have it, Mr. Vaganowski, if you'll circulate it to us. I did circulate a final updated ad litem finding, Your Honor, that does include those numbers. But once we actually have confirmation of lien fully satisfied, then I will finalize one last time, and I'll include the lien and I'll circulate to the court alongside any other documents for the order to invest.
That's perfect. Thank you so much, Mr. Sanchez. Thank you for your time as well. If you don't have anything else for the court, then all of you are excused.
Thank you, Honor.
Thank
you, Your Honor.
Have a very
Thank you,
good
Your Honor.
Take care.
Okay.
Thank you.
All right, Mr. Nunez, who's next?
Judge, I have Mrs. Spots has been here for over an hour on page 2,
Uh-huh.
1179.
Okay,
Do you want me to call it, Judge?
sure. 1179,
Yes, ma'am.
69, 1169.
69. I'm sorry, my mistake, Judge. 69.
Oh, okay, let's call this one. Yes, sir.
Calling cause number 2023 DCV 1169. Austin Jordan versus J. Anthony Johnson et al. Announcements, please.
Elena Sparse on behalf of the defendants, Your Honor.
All right, I know it still shows that Mr. Ruman as attorney of record, but I believe he had already been allowed to withdraw. Is there anyone here on behalf of Augustine Jordan? Was there anybody here in person, Mr. Nunez, or is there anyone in the waiting room?
No, ma'am.
Okay, then this was set for dismissal. I believe we had not had Mr. Jordan appear at any of the hearings since Mr. Ruman's withdrawal. So if you have a proposed dismissal, Mrs. Sparza, if you haven't already sent it, send it. If not, we can probably generate one.
I've got one, Your Honor. I'll send it right now to Ms. Hernandez.
Appreciate your patience. Thank you for your time.
No, not a problem, Your Honor. You have a great day.
You too. All right, who's next, Mr. Nunez?
Page 3, Judge. Top of the page.
Mm-hmm.
Calling cause number 2020 DCV 4192. Victor M. Valles versus Leonila Cervantes et al. Announcements, please.
Good morning, Your Honor. Juan Uraga for the plaintiff, Victor Reyes.
Good morning. Do we have anyone here on behalf of the Cervantes? I did receive your amended order, Mr. Uraga, which I just signed off on this morning. I don't see a set for anything else. Well, let me go back and look. I have the other case set pulled up here. How about you give me?
And I don't think we have any future hearings, Judge.
Oh, so where are we going forward? I've got
Judge, I've been having discussions with the appointed receiver. She provided me with the information for the appraisal company that was, I guess that she made arrangements to have this property appraised. I've had 2 different conversations with the appraisers. They've been promising me that they'll send me the appraisal that they had completed, but I still yet to receive that, Your Honor. So I think I'm going to go back to Ms. Nunez, the receiver that you appointed, and see perhaps whether she can get the appraisal or perhaps work with a different appraisal company because they're not responding with that information.
Well, can I just order them to turn it over?
Maybe, yes.
How about we do that? How
Yeah,
about
I can.
send me an order that gives them 7 days to turn that over to you in the court? Okay?
Perfect. We'll do, Your Honor.
All righty. Thank you very much. I'm going to set you for another status in 30 days, okay?
Thank you, Judge. Appreciate you.
Have a good day.
And bye-bye.
Okay, who's next?
Page 4, Judge.
Mhm.
Calling cause number 2023 DCV 3123. Irma Fong versus the City of El Paso County, Texas et al. Announcements, please.
Good afternoon, Judge. This is Steve Blanco on behalf of the city. Also with me is Assistant City Attorney, Mr. Lemke.
Good morning.
Good afternoon, Your Honor. Good morning.
I
Mr.
see,
Lerma?
I see Mr. Lerma's screen there. There he is.
I'm here now. I'm here, Your Honor.
Okay, Mr. Lerma is appearing on behalf of plaintiff. I do remember at the last setting, there were a lot of T's to cross and I's to dot, so to speak, but there is a note here that we were to have a written response. I see that was it filed yesterday?
Yes.
Yes, it was filed yesterday, Your Honor.
Okay, okay. So I have not reviewed that yet. How about you all refresh my memory on the plan going forward, and let me look at this document.
Sure, Judge. So, Mr. Lerma, on behalf of Ms. Fong, filed a contest and appeal of a ruling from the Building and Standards Commission. The city responded to that, and briefs by both parties have been filed. Mr. Lerma filed his. The city filed their response brief. At the last hearing that we had for the matter, the court asks for some additional documents and also extended an additional response period for Mr. Lerma to provide arguments to address the points that were raised in the city's briefing. Mr. Lerma has chosen to file a very direct and short response saying that we're going forward, relying on the petitioner's opening brief, Ms. Fong's opening brief, the city's response brief, and the information that's been submitted in those two filings. In addition to
Counsel,
those
you
two
need to speak
filings,
please.
Oh, if you
Excuse
can
me?
speak a little louder, Mr. Blanco.
I'm sorry.
That's
In
okay.
addition to those two filings, the court also asked for
Okay, otra vez, honey.
certain record information to be filed by the city, which we did. You have received a certified record. It was delivered to the court on the 15th of the Building and Standards Commission meeting minutes and a certified copy of the order that was entered by the Building and Standards Commission. In addition, a link to the hearing, because Your Honor asked to be able to view the complete hearing if you felt it was necessary as part of your review of the briefing. That link, I believe, was also included in Mr. Lerma's filing, so that's been provided to the court. We did have an open question about that. I didn't know if Your Honor wanted us to transcribe the hearing. It's a video of the hearing, and certainly if that would benefit the court, we can do that.
Are there any issues with I guess the audio or anything of that nature? I mean, are there going to be questions about being able to hear it?
I don't believe so.
Okay.
Yeah, I don't believe so. But if that does pose a problem, we can obviously have that transcribed and delivered to the court. I think at this point, based on our last hearing, it's just a matter now of the court to set a date to issue a ruling
Sure.
on the briefs.
Okay. I'm good with that. Mr. Lerma, do you have anything to add?
No, Your Honor, I submit my brief for the court's consideration, Your Honor.
Okay. And so for those things that were delivered yesterday, yeah, I have not seen those yet, but I want to give a reasonable timetable. If you have some input, I'd like to say 30 days, but quite frankly, we are going to have, well, I'll be out at conference next week, and then we have back-to-back serious trials coming up. So on the 31st, we're starting a very sensitive case, and then I have a murder right after that. And so out of an abundance of consideration just for the trial schedule, I don't want to be too ambitious unless you all are going to tell me there is some urgency. I'm going to utilize the December 2nd date for my deadline to have that ruling. Is that going to pose a problem for either of you?
No, Your Honor.
Okay.
Not on the plaintiff, Your Honor.
Okay, I was going to say 30 days, but that puts me in the middle of trials and before the holidays, so I'm going to just give myself a little bit of breathing room. I will set us for a status on December 4th at 11 a.m.
Okay, appreciate that.
Thank you, Counsel.
Yes, Your Honor.
If you
Thank
don't
you.
have anything else, I appreciate your assistance on this and for your patience today. Have a good day.
Thank you.
Thank you, ma'am.
Thank you, Honor. Have a good day.
Bye.
Bye-bye.
Gentlemen, have a good day.
You too.
You too. Thank you, Mr. Lerman.
Who's next? Mr.
Hey.
Farah?
Yes, ma'am. Page 5, Judge.
Mm-hmm.
Calling cause number 2023 DCV 3025 Marcos Pino Sr. et al. Versus Raul Alberto Rosco et al. Announces, please.
Maled Farah for the plaintiffs, Your Honor.
Brock Akers for defendant.
Good morning. Give me 1 second so I can open up your case. We're set for a motion to compel today. And no, we already went past. Is this on the depositions? Is this the October 4th motion to compel?
Yes, Your Honor.
Okay, let me pull that one up. Okay, Mr. Akers, you may proceed.
Thank you. It's really quite simple. We would like to go forward and start doing some discovery in the case. Plaintiffs want the depositions of our folks first. They've told us and won't agree to any dates until then. Our folks are all subject to the continuing criminal exposure. They will be taking the Fifth Amendment at that time. And we want to move forward. And so we need them to agree to a date or because every time because they won't agree to a date, so we just notice it and they quash it and then we ask for a new date and we don't get a new date. So we're just looking to move things along.
All right. Mr. Farah?
Your Honor, we have asked for deposition dates for the defendant, and each time defense counsel has said that they were going to assert the Fifth Amendment, which is fine, but that doesn't preclude them from sitting for a deposition under the Texas Rules of Civil Procedure. They're still required to sit for a deposition, and if they intend to assert the Fifth Amendment, then they would have to assert it for each individual question. In this case, Mr. Akers continues to resist presenting his client for a deposition prior to taking any other depositions, which isn't proper. Generally speaking, in civil litigation cases, the parties are deposed first, any lay witnesses are deposed thereafter, and any experts are deposed after that. And so in Mr. Akers' own motion, he says we should be doing discovery in a due order. That's the due order of discovery the way it's typically done. And so I'm not sure why we would be taking lay witness depositions when we've requested the depositions of the defendant and they have not been presented yet.
Well, it's quite simple. The depositions of our folks will be a complete waste of time. They have not noticed those depositions. I have noticed the depositions of these fact witnesses. And so if they want to waste their time with a deposition where our folks claim the Fifth Amendment, I mean, that's their privilege, I guess. But there's no reason to wait. The rules do not prescribe some order of how depositions need to be taken. And while the criminal matter is pending, we ought to be able to get at least some of this out of the way.
Did I misunderstand? Am on the two individuals that are the subject of the motion to compel, are you also anticipating that they are gonna raise some Fifth Amendment concerns?
No, they're eyewitnesses.
Okay.
Yes, Your Honor, they're lay witnesses. They are not parties to the lawsuit at all.
Mhm.
And so we requested a party deposition prior to the defendant requesting the lay witness depositions. They've resisted in presenting any deposition dates whatsoever and have simply made a blanket assertion that they intend to assert the Fifth Amendment.
Well, fairly put, they say, well, we need dates. And I said, well, what's the point of having dates where they're going to say Fifth Amendment and then we don't hear anything?
Okay, so the subject of the motion to compel are two different individuals, I guess, lay witnesses. If you hadn't noticed or were feeling some resistance on the individuals, Mr. Farah, that you were wanting to depose, I suppose you could have gone this route as well, irrespective of what Mr. Akers' position was on, if it was a waste of time or not. However, I'm not sure that I see a basis for delaying the depositions of these two individuals going forward. So do you have anything else on the motion to compel?
On this current motion, no, Your Honor, but I would like some concessions from Mr. Akers that he will present his clients for deposition as well, even if he does intend to assert the Fifth Amendment for each individual question.
Well, if that's what we need, I mean, yes, I'll be happy to do that. I mean, it seems like an exercise in futility, but we can do that.
With respect, there you go, Mr. Farrar. I don't know if you have or have not noticed formally any other requests with respect to Mr. Akers' clients, but with respect to this motion to compel, I am going to grant it as requested, setting those depositions within 30 days. Mr. Farrar, if there are any issues on the other individuals that you were requesting deposition dates, feel free to come back to the court for any relief you might need.
Thank you, Your Honor.
All right, Mr. Akers, if you didn't attach an order, please send an order over and I'll sign off on it.
There is an order attached to the motion.
All righty, thank you very
Okay.
much.
Thank you.
Thank you, Your Honor.
Council, have a good day.
And you.
Is that everyone?
That's everything, Judge.
Wonderful. Thank you.
just-
Hi, Christian.
No one did appear for page 2,
Judge.
Page
Uh,
two.
Neos National Bank. No one appeared for that one.
Okay, let's go ahead and call it very quickly.
Yes, ma'am.
This is 2024 DCV 1010 US Bank National Association et al. Versus John Gilliland. May I have announcements? Mr. Nanez, have we received any communication from plaintiff's counsel, or is there anyone in the waiting room?
There's no one in the waiting room, Judge, and I have not received any communication.
And it was set for dismissal hearing. We will go ahead and dismiss that case for want of prosecution. Were there any others were adjourned on that matter? Were there any others that we had no shows, Mr. Nanez?
No, ma'am.
Okay, then that concludes the docket. Thank you very much. We can get off of YouTube.
Thank you, Judge.